Okay, welcome everyone, and thank you for joining us today. Obviously, we're all here for the same reason. Artificial intelligence is pretty rapidly reshaping healthcare delivery, clinical documentation, and patient engagement, and the legal, operational, and the liability implications are evolving just as quickly. And obviously, we're all aware that the stakes are real. AI is no longer optional, but the problem is when AI becomes ungoverned and interacts with regulated litigation-ready data, and it becomes your single biggest emerging liability. I'm David Badie. I'm a healthcare partner at Frier Levitt. I've been practicing law in the healthcare space for nearly 15 years. And prior to joining Frier Levitt, I served as in-house counsel and was also a partner with a large national law firm. My practice focuses on assisting clients across the healthcare spectrum with regulatory and transactional matters, and I've also handled high-stakes litigation around the country for over a decade. Joining me today, we have two professionals working at the intersection of healthcare risk, governance, and emerging technology. We're joined today by Tiffanny Anghel, who's the founder and president of RevTech LLC Consulting, and Kevin Salinas, who is a principal at Epic Insurance Brokers and Consultants. Kevin and Tiffanny, why don't you take some time to tell us a little bit about yourselves?
Yeah, happy to jump on. Good afternoon, everybody. I'm Kevin Salinas, a principal at Epic Insurance and Consultants. So after completing my MBA in healthcare management, I've been in the healthcare industry for about 8 years now in multiple capacities. But at Epic, my practice is focused on professional liability, specifically medical malpractice. And I sit within Epic's risk management vertical. With that role, I work very closely with healthcare organizations on policy reviews, benchmarking, exercising, resulting in identifying more effective risk solutions and cost-saving options. So at Epic, we have a dedicated healthcare practice with a broad national footprint that includes hospital teams, senior living team, captive consulting and management, and my specific team working primarily with private practices and physician networks, which includes MSOs, ACOs, and IPAs. I do have my PNC license, and much of my work involves managing existing insurance policies while evaluating whether alternative structures or markets can better align with organizations' risks and growth strategies. So I'm looking forward to today's discussion.
Great, David, thanks so much for having me. Hello, everyone. My name is Tiffanny Anghel. I have a 20-year healthcare background. I started RevTech Healthcare Consulting, which is a boutique healthcare consulting firm in New Jersey. I started my career in managing practice operations. I then have a master's of healthcare administration from Seton Hall and just completed my master's in health and hospital law at Seton Hall Law. So I've worked in technology companies and deployed solutions across every type of modality. And so, today, as we're talking about AI, EMRs, and liability, we wanted to make sure that you have a breadth of information at your fingertips on, important tools to modernize your practice without exposing yourself to legal risk and repercussions. So with that, I'll be moderating the panel today. And just a few housekeeping items before we begin. This webinar is being recorded, so you will receive a link to access the on-demand replay in the coming days. We do have some slides too that we can share as per request if you'd like to have access to those as well. Please note that today's discussion is for information purposes only. It should not be considered legal, insurance, or regulatory advice. If you would like to discuss your organization's specific circumstances, we do encourage you to connect with us after the program. If you have any questions during the session, please submit them using the Q&A feature. We are going to address as many questions as possible as time allows at the end of the discussion, and we'll follow up with any answers that we're not able to get to as well. Okay. So our roadmap for today, we're going to really talk about 5 specific sections. So first is the legal exposure stack around AI and EMRs. Second is going to be the insurance and claims landscape and the coverage gaps that no one is really talking about and what you need to know as you're evaluating policies. And then the third is the regulatory reality and what enforcement actually looks like. We'll then talk about, what can you adopt in your practice as a practical governance framework for responsible AI deployment, and, questions that you should be taking back to your vendors, and how to really have a good vetting process in your organization. And that's whether you're a small ambulatory practice or, mid-sized practice looking to, join a hospital or, completely stay independent. We know that there's a lot of challenges, with putting a key infrastructure in place. We want to make sure that you have a good understanding of what those are. And then we'll, finally address any key takeaways and action items. So with that, let's get started. So the first section that we're going to talk about is really around artificial intelligence, right? So there's really three sections that are exposed to the legal stack. So first, we're going to talk about hallucination and record liability, and then we're going to talk a little bit about CDI and false claims exposure. So AI deployment around clinical decision support AI tools, as well as revenue cycle AI tools, are really, I think, a lot of the common software components that are being evaluated right now. We will touch on what's called software as a medical device. That's really around medical devices that have an AI component attached to them too. But we're going to really address the first two that I just discussed. So with that, I'm going to turn it over to David. David, I know that you're seeing a lot of legal exposure, and in particular, some cases that have come out recently around risk as it pertains to AI-generated clinical summaries that may fabricate context and become part of the legal permanent record. So do you want to touch on some of that first?
Sure. Yeah. Thanks, Tiffany. So let me start with what I consider the most immediate legal risk. As you just said, AI-generated clinical summaries sometimes fabricate context or have what we call hallucinations, and they become part of what is known as the permanent legal medical record. And the physician is always going to be treated as the author of every word, even AI-generated words. And so whether it's ambient scribes, auto-populated notes, or predictive text, this is being treated by courts and regulators as if the physician wrote every single word. And when those tools make errors or import incorrect information, the physician is still legally responsible. The provider still owns that record. And we're also seeing cases where, and I know this is very popular in a lot of EMRs now. I've seen Epic, I know it's in Epic, auto-populated fields where they pull outdated allergies or incorrect medications or stale diagnoses into the current record. And those errors propagate into new treatment decisions. So you can imagine the problem that causes. And this isn't just a documentation problem anymore, Tiffany. It's extending to AI systems providing clinical guidance without authorization. And you and I were talking before we jumped on the call about a case that was just filed yesterday in Pennsylvania, where the state sued Character.ai after a state investigation found that the company's chatbots were holding themselves out as licensed medical professionals. So in that case, a state investigator interacted with the chatbot, and the chatbot claimed to be a doctor of psychiatry. And the chatbot said that it was licensed to practice in Pennsylvania, and even provided a fake medical license number. So in that case, the state is asking the court to order the company to stop the unlawful practice of medicine. And so why does this matter for your practice, right? Because it highlights a broader trend. Regulators are no longer waiting to see patient harm before they start to act. That may have been the case in the past. That's just no longer the case. They're going after the deployment of artificial intelligence itself. And so if an AI tool in your environment is generating clinical suggestions or diagnostic impressions or treatment recommendations without appropriate physician oversight and validation, frankly, you could face similar enforcement theories as in that case. Now, you also mentioned false claims exposure. Revenue cycle AI tools that are trained on reimbursement, data push documentation towards financially optimal, but not always clinically, precise language. So the AI-assisted coding, even if it's upcoding, even if it's unintentional, can trigger federal False Claims Act liability. And just, very quickly, you touched on, Tiffany, software as a medical device classification. AI-powered clinical decision support tools they increasingly qualify as FDA software as a medical device. And black box machine learning models, they face explainability mandates, right? And so here is an emerging theory that I think is really worth watching. And I bet we'll start to see this. It's failure to consult an AI tool. I think that that's eventually going to be a theory of negligence in some of these cases.
Wow. Okay.
Tiffany, could I just add something to what
Sure.
to what David just said? I think he's super spot on. And something that popped out to me was when he was saying regulators are no longer waiting to see patient harm before acting, which in my lens, in an insurance perspective, where I come in with a different viewpoint, it becomes almost as a simple statement of we're seeing risk surface faster than regulation. So the coverage language hasn't really caught up. It's going to be evolving. And that patient harm is key. And a lot of the professional liability policies, there's need to be a bodily injury or damages, right? So that's, I feel like, where the gaps coming in place, right? So I just wanted to add that before we continue.
No, that's a great point. And we'll talk a little bit about, what are some of those coverage gaps and, if you're a small practice, what should you be thinking about? Or if you're, a digital health organization, what are some things that you should be thinking about as well? So we'll discuss that too. Great. So David, thanks for sharing that context. I think I also wanted to kind of confirm, from your perspective, how are malpractice claims evolving as practices adopt AI? And is the physician still at the last line of accountability?
Yeah, that's a great question. And as I said, definitely the physician is still the last line of accountability. We're seeing sort of a shift, Tiffany, from traditional what did the physician do wrong claims to what did the system allow to happen claims. And regulators and plaintiffs' attorneys, they're increasingly looking at the technology layer, not just the clinical decisions. In fact, in many cases that I've seen, plaintiffs' attorneys are focusing the majority of their efforts and resources during the discovery period on the technology layer, whether it's the audit trails or what sorts of information was uploaded into artificial intelligence platforms. So these plaintiffs' attorneys are looking for what we would call the smoking gun. And the question is no longer whether the physician made an error or whether there was a mistake that was made in the clinical treatment, but whether the practice had the appropriate controls to prevent system-generated errors from reaching the patient. That's really what we're seeing. And in fact, the research out there is confirming this shift. That many recent studies that we found have said that mock jurors were almost 50% more likely to find a radiologist liable, for example, when the physician only reviewed a scan once after AI flagged it, versus when the physician reviewed it twice, once before, and then again once after the AI gave its feedback. So the takeaway here is how AI is integrated into clinical workflow, and that directly affects how juries perceive fault. So if your workflow as a provider, if it does not build in meaningful and documented human oversight at the right points, then you're absolutely increasing your exposure.
Got it. So that really, raises the question about, the technology itself, right? So Kevin, I know that you see this on the insurance side, but David, what happens when the AI tools are the ones that are introducing errors into the medical record? Like how are courts treating those types of cases and claims?
Yeah, I think across the board, and not just like in the medical space, right? But I think AI tends to create this false sense of thoroughness, right? And it's the same when it comes to AI generated notes. In litigation, opposing counsel is going to ask, did you review this note before you signed it? If the answer is no, or if the physician can't really articulate what they reviewed, that becomes a significant liability amplifier. And so the legal standard hasn't changed. If it isn't documented, it's not done. We've all heard that, right? But now we have a new category. It's documentation that looks complete, but wasn't actually reviewed.
Mm-hmm. Got it. So Kevin, I want to bring you back in here. But first, David, from a compliance angle, are you seeing that carriers are starting to ask these same governance questions during underwriting?
Yeah, so I'll defer to Kevin on like the specific underwriting questions, but from a compliance standpoint, carriers are increasingly asking the same questions that regulators are asking, right? Do you have policy governing AI tool use? Do you have validation processes? Do you have audit trails? If you can't produce those documents on governance, you may face both coverage disputes and regulatory exposure at the same time.
Okay, great. Yeah. So, segmenting into our coverage gaps conversation, this is like the coverage gaps that no one talks about, right? And it's really, what do you ask, right? The carriers. So Kevin, from your, expertise, what coverage gaps are you seeing most often when a practice has adopted AI tools? And what are the carriers starting to require during underwriting, like when a practice is using AI? And why don't
Yeah,
we start, why don't we segment this into two buckets, right? One from like a physician and small practice perspective, because I know we have audience members that have their own independent practices, and then from a health system and digital health organization perspective.
yeah, and those are two very important different buckets because the complexity obviously increases, right? And the answer is going to vary. That's plain and simple because the market's also going to vary, right? We're dealing with multiple carriers, multiple markets. They're going to have different requirements. Some have more appetite than others. So the gaps really come in because of the policy language. And like I said, um, insurers are attempting to govern AI faster than the providers because the providers are adapting the AI, but it's very important to what David said. It's what's the policy in place? What's the risk management there, right? They're gonna have to get comfortable with that. So if you can't produce any of those policies, standard procedures, anything along those lines, they're either going to refuse writing you that coverage, or upon renewal, you might have had a policy language that had broad language, right? And it becomes almost a broker's responsibility, and obviously anyone in compliance or within the healthcare organization's team to really make that language a little bit more concise and direct, stating AI versus having almost a blanket policy language, because that's when the predictability isn't there. We won't know what policy is going to be triggered and who's going to defend it and who's going to cover it, right? So, with that being said, the gaps lie in depending on the type of practice you're running, right? We're seeing a lot of more of those AI claims. I think it's about 14% uptick in those AI related claims, but it's not solely because of AI. It's radiology, right? Those diagnostic. But then we could go and say AI with scheduling and PHI information. So it's so vast, and it's a hard answer question to answer, to be honest. But I'll bring it back to smaller private practices, right? The coverages that are needed. Usually it's cyber regulatory policies. Limits vary. Really the standard that you're seeing is a 1 million, 3 million coverage, right? But it really depends on your revenue because there's business interruption. So, what are you losing once you get a ransomware, right? So the scenarios are also very complex and different. It's not a cookie cutter situation, a cookie cutter question, and that goes to hospital systems. For we heard the Change Health, and how that still is, systems are still feeling that today. So
Mm-hmm.
the severity is just, the frequency is growing slightly, because regulation and, I mean, well, legal claims are coming in, but the severity is the real issue here, right? How do you ensure that properly without those gaps? How do you build towers? And that's always, you have to be proactive. You can't be reactive in those situations. So, hopefully that answered that gap question.
Yeah,
But
no, that definitely answers. And one
okay.
thing just to add a point here that I'm thinking about is, you know, where does the accountability lie to as we see larger EMR companies? They're really becoming monopolies in the market, right? And dictating and cost around their services. And where does the accountability line drawn, right? Is that on the onus of the EMR? How can you ask a small practice to go up against a conglomerate like Epic or Oracle? I mean, you can't. So there has to be a good line of defense. And David, maybe you can just kind of talk about this too. Are you seeing claims from the EMR's perspective in terms of going after some of the larger practices and counter suing them?
Yeah, I mean, not yet. I anticipate that's something that's certainly coming though.
Okay.
I can't imagine that those types of claims will not be coming soon, because you're absolutely right. Eventually, even the small practices will say, well, we're relying on the system. And so they'll point the finger back at at the EMR systems, at the artificial intelligence platforms. I think it's inevitable.
Mm-hmm, mm-hmm.
I'll add to that. On the professional liability aspect of it for smaller practices and private practices, it's more important that they don't take the hit due to margins and other factors. But there's always sublimits on these policies, and either administrators or the physicians themselves have a belief that they're properly covered on the cyber side. When there's some limits, there's exclusions, and if they don't have a standalone policy that addresses those that first party liability, because what's happening, what we're seeing is, you're relying on your vendors, right? Good faith, right? So you're trying to wipe your hands clean and say, hey, I'm focusing on the patient, the treatment plans, seeing patients, all that stuff.
Mm-hmm.
That's another layer of responsibility that you really have to think about now, right? So that also creates a gap, thinking that they are properly insured. Once again, upon even renewal, the policy language can change. So if you're not doing a policy review, those are going unseen. So it's just a good exercise, and it's going to evolve. These limits are increasing as the severity increases. So the market is continuously changing.
Yeah. And as we see too with the private equity and the corporate practice of medicine, right? I think we're going to see a lot of claims like, who's responsible? Is it the EMR company, or is it the private equity company that they sold to? That's dictating these types of laws. So I think we're going to see evolving case law from that perspective too. Okay, great. So yeah, the key gap is, most standard malpractice and general liability policies explicitly exclude today AI related incidents, ransomware losses, and regulatory penalties. So reviewing annually, Kevin, would you recommend or provide that?
It's simple. Yeah, it's simple as that. It's simple as it's a constant review. The advocacy is important, and understanding what these policies cover you, because these are legal contracts, So review it with your broker, review it with your compliance officer, but keep it in mind.
Great. So that brings us into section 4 around regulatory reality. I know that was a lot of ground that we covered from a policy perspective, and what you should be thinking about when you're renewing your policies. So and hopefully this is eye-opening for the audiences, and we'll give you some of those recommendations that you can take back to your leadership teams. So David, I wanted to keep you in the spotlight because you mentioned on the regulatory side several times, digging into that. What are regulators actually expecting from practices that are adopting these AI tools? And what would you recommend at the state, and federal level? Like what needs to be done, thinking 5 years ahead?
Yeah. So what Kevin and I were sort of just discussing about liability claims ties directly into what regulators are also now expecting. So the gap between regulatory expectations and operational reality is where most practices are exposed. Okay. And so most people don't really realize it until there's an audit or an investigation. And as we've stressed, regulators expect that when you adopt AI or advanced EMR functionality, you've implemented it with a governance structure, right? So they're assuming, or they expect, that you have those governance documents in place when you're adopting AI. And so that means documented policies and procedures, defined workflows, assigned accountability, and ongoing monitoring, all of those things. And so the operational reality in most practices is very different. Tools get turned on, the staff figures out how to use them, and nobody really documents the decision-making process or the controls, or what's permitted use and what isn't. But unfortunately, HIPAA and state privacy laws, and also even CMS conditions of participation, they all require that you can demonstrate that you have appropriate safeguards in place. You can't just claim that you have them. And so, unfortunately, intent is not a defense. So this is I think, critical for everyone to understand. Good intentions are not a defense. So regulators are not going to ask, did you mean to protect patient data? No, they're going to ask, can you show me your policies? Can you show me your training records? Can you show us your access controls, your audit logs? And if you adopted an AI scribe 6 months ago, but you can't produce a policy that governs its permitted use, then you have a compliance gap. Regardless of whether anything has gone wrong yet or not, the standard is not, did the harm occur? Again, the standard is, were there appropriate safeguards in place? And I think we briefly also, Tiffanny, touched on vendor responsibility, right? And this is, I think, one of the most dangerous misconceptions that I encounter. Practices assume that and I've talked to many practice owners, I've talked to CEOs or COOs, and they assume that if something goes wrong with an AI tool or an integration, the vendor is the one that's liable. And although, like I said earlier, we haven't really seen those claims come to fruition just yet, but legally and regulatorily, that's just not the case, right? You may have a business associate agreement, but that doesn't transfer your compliance obligation. It just means that the vendor has their own obligations. But when OCR investigates a breach, or when a patient sues over an AI-generated documentation error, they're going to come to you first. You are the covered entity. You are the treating provider. Always, the buck will stop with you.
Okay, great. So, if you can't audit it, you can't defend it, you shouldn't deploy it, right? I think that's what we're learning.
That's exactly right. And I don't want to make this seem like it's doom and gloom, and we're saying like, oh no, you absolutely shouldn't, adopt AI and integrate it into your workflow. That's not what we're saying. We're saying don't do it without the proper governance in place, right?
Yeah, and we're going to talk about that too, in a little bit. Okay, great. So, you discussed that OCRs increasingly, focus on risk analysis failures. So if your risk analysis, doesn't address AI tools, then the new data flows, it's deficient, right? By definition. So from the state legislative perspective, we're seeing different states adopt laws, around AI governance structures. Have you done some research around New Jersey's, laws and how that's evolving, or in New York? I know we have a large majority of folks here on New York and New Jersey.
Yeah, we definitely have. We have clients all over the country, and so definitely different states are adopting different regulations. And I think, it's really important if you're operating. Also, we have multi-specialty groups that are operating in like more than one state, or hospital systems that are operating in more than one state, or whatever the case may be. I think it's extremely important to make sure that your governance documents and your integration of AI into your workflow is compliant with whatever state you're operating in. That's extremely important, because it's not the same everywhere.
Yeah, and if you want to comment too about telehealth, organizations, I mean, that's a whole nother topic, right? Having AI deployed within a telehealth platform, for example, are you subjected to different repercussions from every state if there's an event?
Oh, absolutely. Yeah, of course. And so not just on the federal level, right? But also, yes, absolutely on the state level. And that's why, again, it's extremely important to be familiar with what the regulations and the requirements are in every single state that you're operating. That, to me, that's a non-negotiable.
Okay. All right, so we learned, vendor responsibility doesn't protect you. A BAA only goes so far. What about AI and attorney-client privilege, right? I think there's some evolving work around that. There's a new risk vector. So if you want to speak a little bit about that for the group.
Yeah, so this is an issue that I think is extremely relevant, probably for most people on the call. And I want to sort of flag something that isn't, strictly like a compliance issue, Tiffany, but it has, I think, enormous implications for every practice. So in February of this year, the federal court in New York actually issued a ruling on whether AI generated documents are protected by the attorney-client privilege. And the court said they're not. And the defendant in that case used a consumer AI chatbot to draft legal strategy documents and then sent them to his attorneys. And the court said, and number one, an AI tool is not an attorney, obviously. It owes no duty of confidentiality. And actually, in fact, the platform's terms of services in that case expressly disclaim confidentiality. So sending those documents to your attorney after the fact doesn't retroactively create attorney-client privilege. Those documents don't all of a sudden become, privileged documents or privileged communications. And here's why this matters for healthcare practices or practitioners. If your staff or you are putting patient information or compliance questions or legal concerns into a consumer AI tool like, ChatGPT or Claude, whatever it is that you use, you may be creating, discoverable records that your attorney, cannot protect. And if a plaintiff's attorney in a case makes a request for those records during the course of discovery, those documents will be discoverable. And actually, it almost gets worse. The court in that case also found that sharing privileged information that you received from your attorney with an AI tool may also waive the privilege over the original attorney-client communication. So if you get legal advice from your attorney about a compliance issue or whatever it may be, and then you paste that advice into a consumer AI chatbot to help you summarize it or act on it or whatever, you may have just waived the privilege on the underlying communication. So those documents that your attorney prepared for you specifically and were originally covered by the attorney-client privilege are no longer covered. And I think the practical takeaway here is if your organization is using AI to analyze anything involving patient data or legal questions or compliance, you need like enterprise grade agreements. You can't be using consumer accounts or just, using one of the, like I said earlier, one of the platforms that are not enterprise grade. And so your AI governance policies need to address privilege preservation explicitly, not just, data security or accuracy.
Okay, that's good to know. I mean, I think everybody here on this call is smart enough to realize, don't put PHI into a ChatGPT or Claude, AI tool. But also, exposing the group here to what you can try and translate from your attorney is, that could really cost you later on down the line. Mm-hmm. And claims are significant, right? I mean, these are not like, $1,000 violations. These violations can be, up in the millions.
Yeah, absolutely.
Good. Okay. All right, great. So that moves us into, how to really have a responsible AI deployment strategy. What does a practical framework look like, right? And, this is kind of where I've sat in my career, essentially having a governance model, right? So every AI tool and every EMR, module, every integration should go through a defined governance process before deployment. I can't emphasize that enough. So first part of, the whole evaluation structure is you should really have a business case of why we need this, right? Is this going to cost our organization dollars or save us long run? I mean, obviously everybody wants to save time, right? And energy into your daily tasks, right? So I think, and also making sure that you're not from a billing perspective, upcoding, incorrectly. You don't want to be in one of those, named lawsuits for overcoding and That's definitely not good press. Undercoding as well. So we understand the why behind wanting to, be faster in these areas. But having a business case, number one, is key. And really having a good internal discussion with the organization of why we need this should really be the starting point, right? Then it goes into what's called a cross-functional review. So I'm a huge believer of, including clinical leadership, compliance, IT, and your legal teams in evaluating every single contract. Um, you know, uh, Holding some of these questions that after the fact you deployed is really poor execution, right? So and then as you're moving through the process, working with the partner, they should be able to come back to you with targeted answers to any of your questions without too much time to go by. I know it can be very cumbersome working with some of these, tech companies and, going through their whole process internally. I've been on the other side of it, so I know it's very annoying sometimes, but, document every response, document the decision to adopt it, and then the intended use case, and then document any risks that are identified as well. If you can't answer who approved this, and when you have a governance gap, then that's very questionable. And after what we discussed about privilege, your governance process needs to explicitly address which AI tools are approved for use with sensitive health information. Be very clear about how you're evaluating AI tools for sensitive health data. That's like in its own bucket, right? And what types of information may never be entered into a non-enterprise AI tool. So build that into your governance process from day one. Next, when we talk about risk control for each tool, it's important to identify what can go wrong and implement controls to mitigate those risks. So for AI documentation tools, that means mandatory physician review before signature and a workflow that enforces it, not just a policy that suggests it. Then we move into documentation standards around defining how AI-assisted documentation, can be reviewed, edited, and attested. So it's important to train staff on those policies as well. And then oversight, right? So assigning accountability for ongoing monitoring. Someone in the organization needs to own the AI governance process, whether that's a chief compliance officer. If you don't have a chief compliance officer, working with an outside, party is important that has experience in this area. For smaller hospitals, we're seeing, the adoption of a chief medical information officer. That's, a key role in the vetting process, or a designated committee. As many of you have been through, this process with EHR selection, right? It's been a part of the business, right? And most, I would say 95% of providers are on an EHR. We've seen the adoption of EHR executive steering committees, to vet an EHR as a vendor of choice for, an organization. So we're seeing a large framework around AI adoption too. So we are seeing the adoption of an AI executive steering committee to sign off on some of those, some of these decisions, which is important to have in the organization. So just keep that in mind. And then lastly, you can, there's like a 3-part deployment test, right? So can we explain exactly what this tool does and how it affects patient care or data? As we said, can we audit it, its outputs? If you can't audit it and you can't defend it, you probably shouldn't be deploying it. And then lastly, can we defend our use of this tool if something goes wrong? Like, can you defend it to a regulator, a jury, or a carrier? So if the answer to any of those questions is no, you're just not ready to deploy the technology. So build the governance structure first before you adopt. Great. So I know we're at about 1:39 right now. We have about 20 minutes left. I want to make sure we, have time for questions, and then we'll go into we'll do a summary wrap up, closing, and just reiterate some of those key takeaways.
It looks like we do have one question, and probably one that's directed to Kevin. Kevin, can you just repeat the suggested insurance coverages again? I think it was cyber insurance, and then there were others. Can you just repeat that?
Yeah, suggestion again. I think it would be more appropriate to speak to your dedicated broker, or happy for you to reach out to kind of discuss that a little more in detail, because it depends on your organization, right? We're talking about professional liability. Yes, the cyber policy, there's standalone cyber policies that can be accompanied with a crime policy. and there's tech E&O depending on what your practices are doing, if there's any tech exposure there. So I wouldn't want to just blankly suggest insurance coverages, but definitely reach out or speak to your broker on reviewing what you currently have and how your practice is evolving to make sure that that insurance program is covering you properly. So yeah, that's what I would say to that question.
Okay, great. Thanks, Kevin. I don't see any additional questions here. Tiffany, I'll keep an eye on them. Go ahead, Kevin.
Yeah, I'll add something before we wrap things up too. Just things that came to mind while we were having this discussion is with EMRs, because it's the topic here, right? AI is being embedded to a lot of these vendor products that you already had, and it's software updates. There's going to be, glitches or whatever the case might be, but there's a lot of providers out there that don't even know that they're utilizing AI, which is somewhat dangerous to all the points that we're just discussing right now, right? And that's the big a big thing to keep in mind is the overcoding with AI. It hits so many different verticals within your organization that the coverages are just a safety net, but it's the responsibility of the organization to be proactive and work with their team to identify all of this, what we're talking about. So to say what, to repeat what David mentioned, we're not anti-AI. I don't think anyone on this call is anti-AI, right? Don't run away from it, because at the end of the day, you can't be left behind, because the standard of care is going to evolve. So if you don't have certain things in this AI, AI platforms, that might hurt you as well. You might be liable for not being up to date with the new tools to provide patient care. So it's a balancing act, and knowing that balancing act, I know it sounds like a lot, but there is support. There is all these you know vendors or third parties that will support you. And funny, just lastly is there's even new positions. We were talking about CTOs, CIOs, right? There's chief AI officers now. There's new roles. So obviously this is just going to keep growing, and there's a huge importance to keep the spotlight on it as well.
Yeah,
and
educate. And to your point, Kevin, too, just to add, you don't want to be behind, because a lot of the payers are adopting this right now, and they're using it to deny claims, right? And so we want to be ahead of the curve and really deploy these solutions so that you can, prove the fact that you're not undercoding or upcoding, right? And I think another point too to add is that doing your own internal audits can always be a really good source of defense as well, rather than being reactive to an audit. Being proactive and doing one internally and keeping documentation of that, I think is something, that will never hurt you, right, David? I mean, you've been on the other side of a lot of reactive audits, right? And it's never a great situation, especially if you're at a network practice, or you're in network practice. Doing the internal due diligence ahead of time is never going to hurt your claim.
Yeah, I completely agree. Mm-hmm. Yeah, I think being proactive is, especially when it comes to the audits, is definitely key.
Yeah.
We have another question here. A common tool that some clinicians are using is open evidence. Do we have any prediction on how that will play out? Not necessarily a prediction on how that will play out. I think it definitely impacts, clinician liability, because it helps validate clinical decisions. Ultimately, that's really what it's doing. But it also creates, I think, potential risks related to, for example, over-reliance on AI generated information. So I think while it's designed to increase accuracy and reduce, medical errors, I think its usage sort of brings new considerations in both positive and negative ways. So I think that some of the key takeaways there would be to verify and document, maintain your independent judgment. You're still the clinician. You remember, and I always tell clients this, you have hands on the patient. You see the patient. There's no substitute for that. Even if you're typing information into Open Evidence or whatever platform you're using, you're the only one that sees the patient. You're the only one that has hands on the patient. And I don't think there's a substitute for that. So you have to maintain your independent judgment, and verify.
David, I'll add to that as well. Well, what I was recently with some medical malpractice defense attorneys, and we're talking about EMRs, right? How it kind of makes it easy for you, some of them, right? And there's always a note-taking section in your EMR. Write everything that you believe, back up whatever that prediction or whatever that AI spits out at you, and if you agree, just document it additionally. I think that from what I've been told, it doesn't hurt. It just helps.
Right. And then, and David, just from your perspective too, like, would you recommend, like, we don't want to over document, right? I mean, physicians are inundated as it is, like just with like keeping up with the administrative tasks of their organizations, like, what is too much versus like, what's a healthy balance? Like, and where should you be documenting this data? Like in the patient's chart, should it be documented, outside of the patient's chart? Like, what would you recommend?
Yeah, I mean, I know that, obviously, patient care comes first and documentation comes second. But I tell clients all the time that, sometimes the only opportunity that you have to tell, your story about your encounter with your patient is in your documentation. And 3-4 years later, you probably, you may not even remember the patient. And B, you certainly may not remember what the encounter or interaction involved. And so what's the next best place you're going to look? Your medical records, your documentation. So it is, while I understand it comes secondary to patient care, I think it is certainly extremely important to be thorough. And I think it does not hurt to include where you're getting specific information from, but I think it's also equally important to make sure that information is accurate before it goes into the patient's chart. Again, like I said before, the buck stops with the provider.
Got it. All right. Any other questions from the group? I know we have about 10 minutes left. All right, so just kind of recapping everything for the group, 4 takeaways. In the legal space, ungoverned AI interacting with clinical data creates liability that you do not fully understand. Courts are catching up fast. On the insurance space, review your current policies. If they don't have current AI coverage assisted misdiagnosis or regulatory penalties, review your coverage now, not after a claim. On the regulatory side, HIPAA compliant vendor tools do not make your use of those tools compliant. You are the covered entity. Governance documentation is your protection. And lastly, deployment. So 3 questions before any AI go live. Can you explain it? Can you audit it? Can you defend it? If not, build the infrastructure first and then deploy the tool. So with that, just a few, outside housekeeping tips too. As I mentioned, you'll have a copy of the recording, for if you want to share this with any of your, associates in your practice. And again, if you ever have questions, we're here as a resource for you. And we hope that this, webinar was really insightful and just gives you a little bit more, so that you can, practice with ease. So thank you so much for joining.
Thanks for your time. Thanks, Kevin. Thanks, Tiffany.
Thank you, guys.